Your Lordship, I am appearing for the construction and housing company limited, which is developer in this case. Your Lordship, my contention in the commercial code to set aside the award given by the arbitration tribunal was dismissed. Hence, I am here to appeal in this Honorable High Court. Counsel seeks permission to brief the facts of the case. That's a very problem. Your Lordship, Mr. Pinto is the owner of the land, bearing survey number 1/5, measuring 35.7 guntas, situated village Hogli, Bangalore. The owner entered into joint development agreement with the developer for the development of the land. The purchaser herein intended to purchase an apartment in this project, entered into a sale construction agreement with the owner for construction and handing over of the flat, and received an amount of rupees 32,63,720 rupees. When the flat was not delivered as agreed, the purchaser initiated arbitration proceedings claiming relief to the tune of rupees 1 crore with interest at 18% annum, by stating that the developer and the owner are jointly and severally liable to pay the same. Your Honor, to set aside this award that was given by the arbitration tribunal, I had approached the commercial court and they have dismissed my case, and hence I am here before this honorable court. Counsel seeks permission to proceed with the arguments. Much obliged, Your Lordship. Your Lordships kindly refer. Lordship, my contention in the commercial court was on section 34 of the Arbitration Conciliation Act 1996. That is, an arbitral award will be set aside by the court only if the court finds that the subject matter of the dispute is not capable of the settlement by arbitration under the law for the time being, or the arbitral award is in conflict with the public policy of India. For the better understanding of what is public policy of India, we have explanation one, that is, for the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if one, that is, the making of the award was induced or affected by fraud or corruption, or was in violence of section 75 or section 81, or second, it is in contravention with the fundamental policy of Indian law, or third, it is in conflict with the most basic notions of morality or justice. Your Lordships, my contention is on justice, that there is injustice happened for the developer. Your Lordship, kindly make note of this point. Section 18 of the Real Estate and Regulations and Development Act 2016, it says return of amount and compensation. If the promoter fails to complete or is unable to give possession of an apartment, plot or building, A, in accordance with the terms of the agreement for sale or as the case may be, duly completed by the date specified therein, he shall be liable on demand to the allottees in case the allottee wishes to withdraw from the project without prejudice to any other remedy available, to return the amount received by him in respect of that apartment, plot, building, as the case may be, with interest at such rate as may be prescribed in this behalf, including compensation in a matter as provided under this Act. Also, provided that where an allottee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till the handing over of the possession at such rate as may be prescribed. Your Honor, kindly make note of this point. In the sale cum construction agreement that there is clause number 13 under the sale cum construction agreement, which is in page number 27. Your Lordships, kindly make note of this point that if there is any default by the developer, then the purchaser shall be entitled to claim the amount already paid by him to the developer along with rupees 2 per square feet area of the apartment per monthly or delayed by way of damages subjected to purchaser making payment to developer as per payment schedule and intimation as and when it is raised by the developer. Your Honor, in this case, there is no interest mentioned, hence the award granted by the arbitral tribunal for that is 18% is invalid. Your Lordship, there is...
Does the RERA Act apply to this?
Yes, Your Lordship. The judgment that was given by the Commission clearly says that this is registered under the RERA Act. Hence, this is applicable to this case. Your Lordship, kindly make note of this point that under the RERA Act, there is certain rights and duties.
Another question, is there a bar to claim interest under the agreement?
If the it is provided under section 18 that provided where an allottee does not intend to withdraw, then he shall not be provided with the interest, Your Honor.
In the agreement,
Yes, Your Honor.
same.
Yes, Your Honor.
Is there a bar to claim interest?
No, Your Lordship, there is no express bar, but there is a specified term, a specified amount that can be claimed. Hence, if there is any delay delay in payment of that particular amount, then there can be interest levied on that. But here, the award is granted on the entire consideration of the amount by the arbitral tribunal.
Can you elaborate the argument? That argument did not. Only for a portion you can ask for damages or interest.
Clause, Your Honor. Which
The
portion?
argument you are once is now, can you elaborate?
We are telling that on some portion interest is leviable and some portion you cannot. Which portion, according to you, it's leviable and which portion it is not, is what.
Your Lordship, in the clause, it clearly says that the purchaser shall be entitled to claim the amount already paid by him to the developer. That is what the advance that is made by the purchaser to the developer, along with rupees per square feet area of the apartment. And this is exactly what is specified in case that if there is any default by the developer. Hence, if there is a default made by the developer and if rupees 2 per every square feet area should be granted, then the interest can only be given by delay of non-payment of this rupees 2. And since there is no specification that any interest should be granted, there cannot be other interest granted other than this delay. Your Lordship, kindly refer to section 19 of the Real Estate Regulation and Development Act 2016, which talks about certain rights and duties of allottees. Under section 19, subsection 2 says that there are certain duties that should be followed by the purchaser, that is payment of electricity and other amenities, sanitation, and certain services that he needs to be paid. This is one of his duties. Your Lordship, also in the sale cum construction agreement,
Where is the finding in the commercial court that RERA Act applies? Or that is registered?
Your Lordship, page 4 of the judgment.
It is a project is registered. You say this project is registered.
Yes, Your Lordship. The project has been registered under the RERA Act and governed by the RERA Act. Your Lordship, kindly refer to sale cum construction agreement. Charges, clause 9, which is in page number 26 of the Moot Court proposition. The charges to be borne by the purchaser is what clause 9 says. The purchaser shall also pay the proportionate share of such sums as may be required by the developer to meet the following expenses on behalf of the purchaser before taking delivery of Schedule C apartment. kindly take note of this point that before taking the delivery or before demanding for the delivery of Schedule C apartment, he needs to pay certain charges that's mentioned here. Along with A talks about stamp duty and registration fees. Kindly make note of this, Your Lordship. Point number E, deposits, incidental expenses, proportionate fees, charges and expenses for obtaining necessary civic amenities, incidental expenses like water and sewerage connection and electrical power connection, etc., which is currently estimated at rupees 230 per square feet. Your Lordship, this is not paid by the purchaser. Hence, there is a pending.
This construction is not completed. Why is this applicable?
Your Lordship.
This is clause E is applicable provided construction is completed and possession is handed over.
Yeah, Lordship, in the above paragraph it states on behalf of purchaser before taking delivery, that is in third line, before taking delivery of Schedule C
Did you
apartment.
complete the construction?
Yes, Your Lordship. Your Lordship, it is rightly said by the purchaser himself that
Did you call upon him to take possession of the property?
Your Lordship.
Did you call upon your customer
Yes, Your Lordship.
to take possession of the property?
No, Your Lordship.
Completion certificate?
Your Lordship, completion.
Certificate?
No, it's not, Your Lordship. Your Lordship, please refer to Annexure 1, which is in 44, which talks about the stages of completion, where upon completion of each stage, the purchaser has to pay certain amount, that is percentage. Your Lordship, your Lordship, the purchaser has paid 90% of the consideration, and upon possession, there is the agreement that he has to pay the rest of the amount. So 90% has been paid after the 12th stage, that is completion of terrace 4. So only possession was left out, Your Lordship.
Completion of terrace is one thing. That is without completion of the interiors is there.
Your Lordship,
It's just the superstructure which has come up.
yeah, much right, Your Lordship. Your
For
Lordship,
possession, you need to also provide all these amenities and facilities which you have stated here. No?
yes, Your Lordship.
Have you provided all of it?
Yes.
Is there any evidence to show that you finished all that?
There is no evidence, Your Lordship,
You
but
haven't. You should give that evidence.
yes, Your Lordship. Unfortunately, it
Why
was
did you not
not.
plead evidence?
Your Lordship.
You have not pled evidence before the arbitration.
Yes, Your Lordship, but by the statement of what the purchaser himself has accepted, we can take that as an evidence.
Then how can you argue when you did not plead evidence?
Yes, Your Lordship. Due to some reasons, they were not provided any Lordship, and I
Can you
mean,
take that from now?
Your Lordship, there is a certain breach that is made by the purchaser, and counsel seeks to say, and counsel
Where is
says,
the proof for that? If he has breached,
yes, Your
where
Lordship.
is the proof for that?
Your Lordship, the part, clause 9 says, which I have stated right now, that deposits is not paid by the purchaser, and there is a clause of material breach.
These are all clauses. Where is the evidence that there is breach? Did you need evidence is what is asking?
Your Lordship, the deposit has not been paid by
Did
the,
you need evidence to that effect that the deposit is not made?
Uh,
There was breach. I called upon him to pay. I offered for taking possession. Did you do all those?
no, Your Lordship. Due to certain statements that was made by the
What
purchaser,
statements?
Your Lordship, kindly refer to Expedition 9. Expedition 9. Expedition 9. That is page number 84. Point number 4. The purchase says, I mean, the advocate contains that our claim further states that the quality of the construction and the maintenance is not up to market standards. Your Lordship, here he is negligently degrading the quality of the construction where there is no proof provided. And because
How is supposed to prove that the quality is correct? He is alleged against you. Did you step into the witness box to say that it was correct?
No, Your Lordship. Your Lordship.
Or please, when you cross-examine the claimant,
Yes, Your
can
Lordship.
you put questions?
Your Lordship, it was not questioned, but the fact that because of this statement made by him, the other buyers, Your Lordship, this project is something where all buyers have to pay their part of the amount for the construction to be complete. And because of his statement that is made, the other buyers are also influenced by this part, and the entire construction is being delayed.
Where is the proof of that?
Yes, Your Lordship, there is lack of
delay.
Yes, Your Lordship, there is a lack of evidence to say all of these things, but my contention is that there is a big fault on the purchaser side, and he is blaming everything on the developer.
You say contributory default. Contributory default.
Contemporary default.
Contributory default saying one should knock off the other. Your default and his default both exist. Therefore, he should be paid the money.
Your Lordship, I would like to say there is fault on both the purchaser and the developer, and this could be solved amicably. There is an arbitration clause which clearly says that before approaching the arbitral tribunal, they could sit together and solve all the issues. And he was not ready, the purchaser was not ready to solve the issues because he has
The issue notice to you.
Your Lordship.
Did you raise that? Is it amicably? Did you raise it?
Before the arbitral tribunal. No, Your Lordship.
When he issued notices to three notices were issued.
Yes, Your Lordship.
Did you reply?
Your Lordship, there is no need to answer to those notices provided by him because there is a delay caused by the purchaser himself. And Your Lordship, the part that Your Lordship, kindly make note of this point, that is the loan that is taken by the purchaser, that is for the
Even the arbitrator is not awarded the interest on the loan.
Your Lordship.
Arbitrator is not awarded any interest on the loans that he has taken. Right?
Your Lordship, there are 9 claims made by the.
Arbitrator is only awarded interest on the amount paid by him and 2 rupees as damages.
Your Lordship, he has awarded 18% on the entire
I
consideration.
know, that's what basically on whatever he has paid you,
Yes, Your Lordship.
he has directed refund and 18% interest.
Yes, Your Lordship.
But he has not awarded the claim which he had made that he had to pay interest on the
All
loan.
other claims have been denied.
Yes, Your Lordship, but my contention is that there is a fault on the purchaser himself, and when he is not come in clean hands to this court, I mean, how can he claim for such damages, putting entire fault on the developer himself?
What are the unclean portions of his hand?
Your Lordship, like I mentioned, he's not paid the deposits, and there is a breach of contract. Also, Your Lordship,
When was it called for?
Your Lordship,
When was it called for, the payment? Payment due? When was it called
Your
for?
Lordship, before Your Lordship, there is actually a demand that has to be made by the developer, and the demand was not made. And since he was demanding the possession of the property, before demanding for possession of property, he needs to pay all of these, and then only he has a right to ask for possession of the property.
Did you tell him that?
No, Your Lordship. Your Lordship, I just want to point out one single thing. Your Lordship, for this particular Schedule C apartment, the purchaser has taken loan on March 2012. And then the term that is given to him, this is in Expedition 463, page number 63. The term that is provided to him is 240 months, that is 20 years. Your Lordship, he claims that he's cleared the loan.
5 years.
Yes, Your Lordship, he's cleared the loan in 5 years, which is mentioned in page number 173. And Your Lordship, he's taken the second loan, that is in the month of May 2019. Your Lordship,
That's a different project, right?
yes, Your Lordship. Your Lordship, that was for a different project. By all of these, the sentences which a negligent sentence that he has made, that this is not up to the standard, not up to the market standards, and also substandard, and not up to the reputation that they posed themselves, and also these fast payment of these loans, we can clearly say that he had malintention while he was, Your Lordship, while he finished the payment of the 12th stage, that is of the terrace, completion of terrace, I would like to say that he came across a different one when he lost interest in his Schedule C property, and that's why within just in the span of 1 year, 5 months, he's taken a loan again, and he wants to claim all the damages that is he is borne, that is the rent, everything, and since the award is not.
But there is not, that's not the defense before the arbitrator. You are raising it for the first time now. It was 57 appeal.
Your Lordship, I agree. I
Too
have.
difficult to accept
It's
that.
not go beyond the scope of section 34.
I agree, Your Lordship. I have one final contention to say that this agreement itself is valid. Your Lordship, the stamp duty paid by the purchaser it's in page number 18, that is 3,450 rupees. Your Lordship, according to Karnataka Stamp Act, that is Article 5, Sub-Article E, which says possession of property is not delivered, then for every 100 rupees, 10 paise should be paid. That is, Your Lordship, his consideration is 98,800 rupees. The consideration, total consideration is. So the stamp duty that he has to pay comes around 3,598 rupees, rounded off to 3,600 rupees, and that is not paid to the government promptly, Your Lordship. Hence, when the stamp duty is not correctly paid, we can say that this agreement is invalid.
Invalid.
Yes, Your Lordship.
Under the stamp act.
Yes, Your Lordship.
What is the effect of not getting the stamp duty?
Your Lordship, he has to pay penalty before proceeding of any of the other
You
contentions.
ask the arbitrator to impound the document.
Was it marked? Was the document marked?
Your Lordship, it's under page number 18
Is
and
it marked? Is it marked?
under expedition 1.
Is it marked?
Yes, Your Lordship. Yes.
After that, could you raise this now? After marking, getting it marked, could you raise that now?
But Your Lordship, this was not brought about in front of the court in lower
You are not
courts.
a signatory to this document. Are you a signatory to this document? You're seeing it for the first time today.
Your Lordship, it is marked, but it is not brought before the court. If it was brought before the court, then the penalty would be paid.
What exactly do you mean by not brought to the court?
In the lower court, Your Lordship.
This point is not raised. You see, this point is not raised.
It was not raised, Your Lordship. And
Then again, too late.
but Your Lordship, in this particular page, it only says page number 18, and sale of agreement is marked as expedition
So
1.
you'll be happy if you direct your customer to pay 3,600
No, Your Lordship.
and you pay the rest of the claims.
No, Your Lordship. Your Lordship, my final contention is that there is a breach on the purchaser. Like I stated, material breach and not payment of deposit. Hence, I pray before this honorable court to set aside the award. Much obliged.
I think that. Your Lordship.
And the advocate for the respondent in this case. The brief facts of the case being that I, on the basis of a newspaper advertisement, approached Mrs. Construction and Housing Private Limited in order to buy a flat, an apartment, in the property that they were constructing. When I approached them, I was given to understand that there was a joint development agreement between the constructing company, the Construction and Housing Private Limited, and one Mr. Pilger, whose property it was. And I entered into an agreement with them on the terms and conditions. Your Lordship can have a look at the agreement at page 19 of our sale cum construction agreement. Page number 24, Your Lordship, it says at para 6, completion and handing over or possession. In that it says the possession of Schedule C apartment will be delivered by the developer to the purchasers within 13 months from the date of obtaining the commencement certificate from the concerned authority, subject to further extension grace period of 6 months thereafter. The developer shall not be liable for delay caused in completion of construction and delivery, and they have given a series of reasons where in case of such a delay, he will not be held liable. And further, Your Lordship, it says, in case I was to delay in payment, they have given me a schedule according to which I was required to pay. At page number 26, Your Lordship, paragraph 10, it says, in the event there being any delay in payment of any of the aforesaid amounts by the purchaser, interest at the rate of 18% per annum shall be payable by the purchasers for the delayed period from the due date until the time of actual payment. Here, Your Lordship, it says that in case I delay, I am required to pay 18%. And in the same agreement at paragraph 13, Your Lordships, default by the developer. It says, if owing to any willful act and or default of the developer, the possession of Schedule C apartment is not delivered to the purchasers even after the expiry of 6 months grace period stipulated in clause 6 above of the agreement, or within such further dates as agreed by the parties herein, the purchasers shall give notice to the developer of their intention to terminate this agreement, and if the developer willfully fails to deliver the possession of Schedule C apartment within 30 days from the date of receipt of such notice, the purchaser shall be entitled to claim the amount already paid by him or her to the developer along with rupees 2 per square feet area of the apartment per month of delay by way of damages. Your Lordship, you will notice a difference that is in case of default by the builder and the default by the purchaser. The default by the purchaser requires the purchaser to pay 18% interest, while they will pay less than about 2 or 3% interest, which if you work out rupees 2 per square feet area of the apartment per month of delay.
That's the agreement between the parties. What can an arbitrator do? Can the arbitrator go outside the agreement?
Your Lordship, in this connection, I would like to bring to your notice a judgment of the Supreme Court in the case of Wing Commander Arifur Rahman Khan and DLF Southern Homes Private Limited. At paragraph 22 of the judgment, Your Lordship, it says, the only issue which then calls for determination is whether the flat buyers in these circumstances are constrained by the stipulation contained in clause 14 of the ADA, providing compensation for delay at the rate of rupees 5 per square feet per month. In assessing the legal position, it is necessary to record that the ADA is clearly one-sided. Where a flat purchaser pays the installments that are due in terms of the agreement with the delay clause, 39A stipulates that the developer would at its own sole option and discretion waive a breach by the allottee of failing to make payments in accordance with the schedule, subject to the condition that the allottee would be charged an interest rate of 15% per month for the first 90 days and thereafter an additional penal interest of 3% per annum. In other words, a delay on the part of the flat buyer attracts interest at the rate of 18% per annum beyond 90 days. On the other hand, where a developer delays in handing over possession, the flat buyer is restricted to receiving interest as rupees 5 per square foot per month under clause 14, which in submission of Mr. Prashant Bhushan works out to 1 to 1.5% per interest per annum. Would the condition which has been prescribed in clause 14 continue to bind the flat purchaser indefinitely, irrespective of the length of delay? The agreement stipulates 36 months as date for handing over the possession. Evidently, the terms of agreement have been drafted by the developer. They do not maintain a level platform as between the developer and purchaser. The stringency of the terms which bind the purchaser are not mirrored by the obligation for meeting timelines by the developer. The agreement does not reflect an even bargain.
Was there an arbitration proceeding?
Pardon?
Was there an arbitration proceeding or was it a RERA?
Your Lordship, this is not this is a Supreme Court judgment. It is not an arbitration proceeding, Your Lordship.
No, no. Question is, did it arise of arbitration?
No, Your Lordship, it is not after arbitration.
So how do you see in arbitration and arbitrator is bound by the terms of the contract. You can't go outside it. Because he is also a creature of the contract.
Yes.
So how can he then decide contrary to the contract and award interest at a rate higher than what is agreed? Maybe under the RERA Act, the adjudicating officer can do it. Maybe a court can do it. But can an arbitrator do it?
Your Lordship, an arbitrator is appointed mainly to give some kind of a justice. Here, we have a
In
case
accordance with
law.
law.
Your Lordship, under section 74 or 73 of the Contract Act, compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew that when they make the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach.
What about 74?
74, Your Lordships, when a contract has been broken, if a sum is named in the contract as the amount to be paid in each case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty.
2 rupees is covered in section 74. That's the maximum you can get.
Your Lordship, if you look at the way the amount that has been suffered, then it becomes a business for the developer, Your Lordship. All contracts these days are being made along these lines, where a layman gets into an agreement with the developer and does not understand the terms of the contract. So if he restricted, then a gross injustice is being done to my client, Your Lordship. He not only is required to pay 18% in case of default, he is also, he continues to live in a rented apartment and continues to pay. He has taken a loan from the bank for which he is required to pay an interest. He is also, because he was not getting this apartment, he has also gone and purchased another apartment for which he has taken another loan and he has paid for that. Your Lordship, considering the compounding interest that he has paid, what he has asked for.
Public interest argument, but how do you change this, the arbitral award?
All your claims, more than claim number 1 and 2, they are beyond the scope of claim.
Pardon, Your Lordship?
All of you have claimed, I think, there are 5 claims from your
Yes,
side.
yes, Your Lordship, and I have got only half of it. I have got,
And whatever you have claimed, other than the money you have paid to the developer, they are all very remote. That's you say in section 73.
section 70.
You have taken a rented house, that is, you have to take a rented house.
Your Lordship,
For your
if,
living, you want to have a house. If you
Precisely,
pay, if
for
you pay
my
rent, how
living-
can you claim from the developer?
Your Lordship, for my living, I have applied for this apartment and I was given an assurance that I will get it within 36 months. Beyond those 36 months, Your Lordship, I'm forced to take it. If I had an apartment of my own, I would not have to pay, Your Lordship. It is not remote, Your Lordship. It is directly connected to this transaction.
But you did not challenge, did you challenge the arbitral?
Yes.
You challenged.
We did not challenge the arbitral award, Your Lordship.
Then
We
the question,
accepted.
you are asking for more money.
No, I'm not asking for more money, Your Lordship. I've got 56, I would like to remain with 56. I do not want to lose any more money. That is all in my submission.
But if you lose the interest, what happens? I mean, do you have any other argument on the interest portion of your case? Refund of money, of course, the contract itself says you are entitled to refund.
Your Lordship, I would like to be placed on the equal footing with the developer. If the developer is entitled to 18%, developer being the kind a big developer having financial resources, I being a lay person who takes a loan from a bank, I should be given, should be placed on an equal footing with the developer, Your Lordship.
You haven't answered one question which I asked you. Can an arbitrator go outside the terms of the contract?
Your Lordship, the arbitrator's judgment, if you look at it, he has explained it, Your Lordship. It says at para 30, Your Lordship,
Page number?
page number 212. Page number 211, it starts, Your Lordship, in circumstances the interest payable on the refund amount at the rate of 18% is just and reasonable, and it would be in conformity with the spirit of the relevant terms engrafted in the document. The various claims based on the alleged investment in purchasing another apartment, etc., he's left them out. He goes on to say that on the above analysis, the conclusion is inescapable that the claimant is entitled to recover refund of the amount of 32,63,720 paid by him towards the purchase, together with interest of 18% per annum on the said amount.
Will the other party raise a contention that you can't get more in the arbitration proceedings?
In the arbitration proceedings, they have not come up with that. No.
Can they raise it now?
No, Your Lordship, now they cannot raise those questions.
But why did you raise that first thing? We can't raise that as an argument now.
I'm sorry, Your Lordship. Yes. They cannot raise it at a belated stage, Your Lordship.
So you are defending the judgment of the hardship.
Yes, Your Lordship.
So what should be your point of argument?
Yes, Your Lordship. I agree.
Can the court look at arbitral award today, or should we only look at the commercial court's judgment?
The commercial court's judgment, Your
We
Lordship.
should not look at the arbitral award.
I mean, as the background of the case, Your Lordship may look at the arbitral award. But the case is based on the case is challenging the commercial award.
What if the commercial court gives reasons which are different from the reasons given to the arbitrator? Then what happens?
The case will have to be looked at in its holistic manner, Your Lordship. But so long as it is defending the claimant's claim, I'm happy with it, Your Lordship.
Do you have anything else to add on?
No, Your Lordship.
We'll ask you one question then.
Yes.
What is the scope of section 34? You've not touched upon that. You've gone into merits of the case. Suppose we
section
disagree with you on the merits, can we set aside the award?
No, Your Lordship, there's in section 34 categorically states the circumstances under which an award can be set aside.
What are they?
It says an arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that a party was under some incapacity, or two, the arbitration agreement is not valid under the law to which the parties are subjected it, or failing any indication thereon under the law for the time being in force. The party making the application was not given proper notice. The arbitral award deals with a dispute not contemplated or not falling within the terms of the submission to arbitration, provided that if the decision of matters submitted to arbitration can be separated, and the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties.
Which grounds have they raised in the section 34 proceeding?
Yes, Your
Which
Lordship.
grounds have they raised?
Your Lordship, they
Which
have
ground is the court considered?
the court, Your Lordship, in the judgment, Your Lordship, it says they have not come up with any specific listing of any of these grounds. It only says at page 17, Your Lordships, para 40, 16 and 17. It can therefore be said that this question has now been settled finally by at least 3 decisions of the court. Even otherwise, to state that the judicial trend appears to favor an interpretation that would read into section 34, a power to modify, revise, or vary the award would be to ignore the previous law contained in the Act, and goes on to say that.
Counsel, is there any one particular judgment of the Supreme Court you want to cite to speak of the scope of section 34?
The National Highways Authority of India Limited, Your Lordships. It goes on to say, it has been pointed out herein that in the law, the court set aside the award passed by the majority members. The underlying disputes would require to be decided afresh. Under section 34 of the Arbitration Act, the court may either dismiss the objections filed or uphold the award set aside if the grounds contained are made out. There is no power to modify an arbitral award.
But we can set aside a portion of the award.
On these grounds alone, Your Lordships. On these grounds.
That is contrary to the contract.
That's the basis.
Your Lordships, that is why I quoted the Supreme Court judgment here, Your Lordships.
It's not an arbitral proceedings, you say.
It is not arbitral proceedings, Your Lordship, but it is on the basis of a contract. There is a contract between the parties, and the conditions of the contract are similar to the case that I have at hand. And in that, the Supreme Court has observed that this is an unfair contract, and it is only one-sided and it cannot be held.
So why can the arbitrator then say, if the developer claims, I also give him only 2 rupees, instead of giving you 18%?
Pardon, Your Lordship?
You said because there is 18% for delayed payment, you should also get 18%.
Yes.
Correct?
Yes.
What if it is the reverse? For delayed payment also you can get only at the rate of rupees 2 for the developer. Can you change the contract that way?
No, Your Lordship.
So how can you change the contract for you?
Your Lordship, when the contract was made, it was made on unfair terms. It should have been made on fair terms for both of us. If it was true for
You are a
rupees,
party
it
to the
would be-
contract. You are a party to the contract.
Agree, Your
How
Lordship.
is it?
I agree, Your Lordships, much obliged, Your Lordships, but what I am only trying to say is that when a layperson signs a contract, he is not aware of these things, and that is why we look up to you, Your Lordships, to uphold our rights.
You don't seem to be a layperson. So late, 10 months you have prepaid your loan, you've immediately gone and purchased another apartment. You seem to be financially okay also.
And financially okay, Your
So you
Lordship,
don't
and
seem to be so layperson that you claim you do not know the contents of the agreement.
Your Lordship, being financially, I beg your pardon, Your Lordship, being financially sound does not mean I'm legally sound. I do
Can
not
that be a
know the
difference?
law, Your Lordship, I
Can
know
that
how to
be a
earn my
difference?
bread.
Can that be a difference? Not knowing law, can that be a difference?
No, Your Lordship, ignorance of law is no difference, I agree with you, Your Lordship. But the point is that when I have come to you, Your Lordships, I am expecting justice, I have paid so much, and why should a developer benefit at my cost, Your Lordships? Why should I lose out, Your Lordships?
Would justice be giving you what is contained in the contract?
Contract.
No, Your Lordship, this entire contract is one-sided.
Did you prefer to challenge the law?
Pardon, Your Lordship?
Did you prefer appeal? Did you approach under section 34, challenge the law?
No, Your Lordships, that I've got so much, I'm grateful.
What right do you have now?
Pardon?
What right do you have now?
I'm not asking for extra amount, Your Lordships, I'm just asking Your Lordships to uphold this order.
Contrary to the terms of the contract. I should consciously enter.
But your whole argument was to give you something more than what the arbitrator has given.
That is what I have claimed in the first place, Your Lordship, but I am not getting it. So I am happy with what I have got. I would like Your Lordship to uphold that. That's my
Warm greetings to the bench. The council would like to collectively address the bench as your lordships. Much obliged. May it please this honorable board, this is council appearing on behalf of the appellant, that is Construction and Housing Limited. In the instant case, the petition is filed before this honorable board under the section 37 of the Arbitration and the Conciliation Act. The council would like to give a brief revisit of the facts. Much obliged. Well, also in the instant case, the defendant one, Mr. Halappa, obtained a sale construction agreement dated on 6/12/2011 from the petitioner and the defendant number 2, who entered into the joint development agreement dated on 19/7/2004 for the construction of the Schedule A property as present under the Schedule B for the flat Schedule C. My lords, as per the agreement, the possession of the delivery of the possession was to be transferred within the 30 months after the commencement certificate dated on 4/7/2012 with the grace period of 6 months, as provided under the section, as provided under the clause 6 of the Safecom Construction Agreement. My lords, it has been recorded by the sole arbitrator that due to the delay in the transfer of possession, the defendant one has approached the Honorable Court under Section 11 of the Arbitration and the Conciliation Act 1996 to initiate the proceedings of the arbitrator and appointed the sole arbitrator. On 2nd February 2021, the arbitral award was passed by the sole arbitrator, and this has been challenged before the Commercial Court under the Section 34. Aggrieved by this, The appellant has appealed before the Honorable High Court under the sections 34. The council would like to address the issues in a twofold manner. Firstly, whether the commercial court was correct in not considering the substantive law for passing the decree under section 34, and also whether to set aside the award passed by the arbitral tribunal. My lords, beginning with the maintainability of the section 37 of the Arbitration and Conciliation Act, which states as follows. For setting aside or refusing to set aside an arbitral award under the section 34. My lords, under the section 34 of the Arbitration and Conciliation Act, clause 2, D2 states that an arbitral award may be set aside with the court only if the court finds that the arbitral award is in conflict with the public policy of India, with explanation if it is in the contravention with the fundamental policy of Indian law. My lords, the fundamental Indian law is nothing but the RERA Act. According to section 19 clause 4, my lords, the allottee shall be entitled to claim the refund of amount paid along with the interest at such rate as may be prescribed and compensation in the manner as provided under the Act. My lordship, the provision under the RERA Act is being violated by the arbitrator because exceeding the amount of interest to be stipulated on the total amount.
So you admit that interest has to be paid.
Yes, Your Worship.
Only the question is, what is the rate? There are only issues on rate.
Yes, Your Worship. But 18% should not be.
What is the rate which is prescribed in Karnataka? It says prescribed rate. That's what you're reading. What's the rate that is prescribed in the state of Karnataka?
My lords, it is there in the sale from agreement.
Prescribed means prescribed by the government.
Okay. So, the allottee shall be entitled to claim the refund of amount paid along with the interest at such rate as may be prescribed and compensation in the manner as provided under this Act from the promoter if the promoter fails to comply or is unable to give the possession of the apartment, plot or building as the case may be in accordance with the terms of the agreement for sale or due to the discontinuance of his business as a developer on account of suspension or revocation of his registration under the provisions of this Act or the rules or the regulations made thereon hereon. My lords, with
You're
the
saying interest is paid. The only question today is the rate.
What is the rate of interest paid?
yes, Your
Now,
Lordship.
the arbitrator has awarded 18%.
Yes, Your Lordship.
You would say that it is on higher side.
Yes, sir.
Then what is the rate paid accordingly? How much should have been awarded?
And should it be compounded? Or should it be simple? Where do you find it? Where do you get it?
The council seeks in one
So when you are referring to that section,
Yes, sir.
prescribed means where do you find that rate of interest?
So are you willing to give 15%?
The council is not aware.
Are you willing to give 15%? Now since you're saying I can't give 18%, are you willing to give 15%?
Or 16.5. What will you choose? Are you choosing or is there anything else?
According to you, what is the rate of interest paid? Not 18. What is the rate of interest that you are agreeable to?
The council would like to pay the interest of 10%.
What is
per annum.
Why not 11? Why not 9.5?
It is not mentioned.
Okay, now that's one thing. Now can the High Court modify that award from 18%?
Indeed, no.
Huh?
Indeed, no.
Indeed means no.
Indeed, no.
So
Respectfully.
if you can't change it, how will you change it to 15% or 12% or 10%? You're using the thing 10%. But how do we change it? We don't have the power to change it.
Hence the council.
Hence the award has to be accepted, that's all.
No. the council, please refer this court to dismiss the arbitral award and reinitiate the,
You're an appeal. And admitting the High Court cannot change anything.
No, I think council is saying that if you can't change it, you will set aside the award.
Who
So
said
it's
it?
wrong.
Set aside the entire award.
yes, Your Lordship.
But
No,
you
you
admit
admit
that the principle is
default.
failing.
She admits default.
If you admit principle is failing, that is the.
Yes, please.
Then how the entire award is set aside when you acquit the principal being paid? How can you say that entire award?
Well, Lordship, but the principal amount to be paid is more. The sole arbitrator is prejudiced when it is considered on the aspect of the petitioners. It is charging more interest.
How do you substantiate your argument that he is guilty?
It is against the section 19 clause 4 that the council is not aware how much percentage should be awarded.
When did the RERA Act come into force?
Yeah, with reference to the page 5 Lordship.
When did the RERA Act come into force?
2016,
So the agreement is which year?
2011.
How does the RERA Act apply?
But Your Lordship, the arbitral award was passed in 2000.
When was the agreement,
2021.
when was the agreement terminated?
In 2011,
Terminated.
Terminated.
Date of termination.
21.
Termination is 21. Are you sure? When did your customer terminate the contract?
In 2012.
Have you read the claim petition?
Yes.
Please read. Six, 12, 14.
2012. I was not aware of the date.
17/10/2016, termination. 16. So then how does the RERA Act apply? RERA Act, how does it apply?
Because Your Lordship, the arbitral award was already given in the 2021.
No, but on the date of termination of the RERA Act in force,
No, Your Lordship. It was not in force.
there was no contract to which you can apply the RERA Act. How can you apply the RERA Act? So let's assume RERA Act goes, then what? Then there's nothing left to challenge the arbitral award.
No, Your Lordship, even according to section 73 and 74, which speaks about the breach of the contract, it should be, the amount should be given according to the law, how much it is stipulated, which is mentioned in the clause 13 of the sale construction agreement, where rupees 2 should be paid for square feet, which is that. But according to the council would like to draw the attention of the bench to page 11 of the judgment, where the second where it says that according to paragraph 21 of the award, which speaks about the entitlement of the claimant, refer to various decisions by relying upon the clause number 13. The calculation made by the learned arbitrator to grant 1,50,304 rupees is exorbitant and without any basis, the arbiter has not considered the decision cited
Those
before him.
are the arguments you are referring to, not the
The
findings.
judgment. The judgment itself says that the arbitrator has charged
That he
more.
has calculated according to this.
So which page are you reading?
Page 11 of the judgment copy.
Of the award.
On the
Of the judgment copy.
You see parallel, which
Para
starts.
8 starts with last second line.
No. What does it say?
You are-
It is just an argument.
You're
that
reading
is
para 8,
advanced.
is it?
Yes.
See the
It's
first
an
line?
argument advance.
First line of para 8 at page 10.
Yeah.
While canvassing,
His argument, learned counsel took the court to claim made by the first respondent and the issues framed, and also liability passing to the petitioner and the second respondent according to the learned counsel.
according to the learned counsel, like you are arguing, the learned counsel there argued like this.
But you also hear the learned arbitrator itself, it is shown in the second line where the learned arbitrator has misused the clause 13 and paid 1 lakh.
See,
That's
thereafter
sufficient.
he took the court to para 29.
Yes, Your Lordship,
He means who? read the page 11 thereafter he took the court.
Paragraph 10, last part.
Not parallel.
Page 10.
Page 11,
Yes, Lord.
on 5th line thereafter.
Thereafter.
Reading from there, right?
Yes,
Thereafter he took the court, means who took the court?
the council.
Yeah, that's not the finding. Where is the finding? Where is the finding of the commercial court?
From which para finding starts?
From the commercial council. Page 212, para 30. In the map.
Of the which para finding?
Of the arbitral case.
That is arbitrary stuff.
Yes, sir, in the commercial
Commercial order. From where does it start?
in the para 30 of the page 212.
So according to this award is a fundamental policy of Indian law,
Yes, sir.
which is a rare act.
Yes, sir.
But it's a rare
There is
act.
a clear violation that the substantive law itself is not used. They have directly
Okay, now tell us,
seek for the
did
damages.
you raise this contention of rare act before the arbitrator?
No.
What happens then? If the arbitrator has not examined your contention, can the section 54 court consider it for the first time?
Hence, you also aggrieved by the dismissal of the petition only the council has appealed to the arbitration.
No, if you can't, if you didn't raise an argument before the arbitrator,
Yes, sir.
could you have raised it before the commercial court? And if you haven't raised it before commercial court, can you raise it before the high court for the first time?
It was your appeal. It was 34, you appeared before the, you approached the commercial court
Yes, sir.
under section 30. It will take this point, it raise this point.
First, the council had appeared before the commercial court. Again, it was dismissed stating that there is a violation of the terms of the
What
bond.
was your ground before the commercial court? What was your ground before the commercial court? What did you challenge the award for?
That there was the violation of the terms of the bond. There was no violation of the.
No, you also taken the ground is against provisions of rare act.
Yes, sir.
Point number 1. But do you want to argue something about no provision for interest in the contract?
Lordship, the interest has been provided under the RERA Act.
Not in the rare act, in the contract, in the sale and construction agreement. Do you want to argue the point that there is no provision for payment of interest by the developer to the purchaser?
No.
You don't want to raise that.
So, Your Lordship, with reference to the clear violation of not using the substantive law and also by claiming the damages of rupees 2 per square feet, the arbitrator being prejudiced to the petitioner has granted 1,50,304. Hence, the counsel for the petitioner plead before this honorable court to dismiss this arbitral award and to reinitiate the award.
How do you reinitiate an arbitral award? If we uphold your contention and set aside this award, saying let's say it's contrary to RERA, under which provision can you restart an arbitration?
According to section, according to section 34.
There's no provision in 34 to restart an arbitration. See section 43.
Of the individual. Section 43. Hence, the counsel plead before this
Read
honorable
section
court.
43. Is there a provision? I'm simply giving you a section. It's not there.
It speaks about the limitations.
What's the last part of the 40?
When the court orders that an arbitral award to be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act for commencement of the proceedings with respect to the dispute so submitted.
Does that help you in any way to restart the arbitration?
Indeed, Your Lordship.
How? It's only a limitation.
It's limitation. How would it help you?
Because there is the limitation time is not exceeded by 8,000.
Anything else?
No, the council raised before this court to dismiss the arbitral.
Dismiss the appeal. Your
Dismiss,
appeal.
no, Your Honor.
This is your appeal.
Arbitral award, to dismiss the arbitral award which was given by the solo arbitrator
Set
and to
aside-
reinitiate.
set aside the arbitral.
Okay, set aside
Allow
the,
the appeal, set aside.
set aside the, apologies.
Otherwise, we'll dismiss your appeal and that's the end.
No, Your Honor. To set aside the arbitral award and to reinitiate according to the section 43 clause 4 of the arbitration reconciliation. It was an honor to be before you. The council appearing on behalf of the respondents in the case of Construction and Housing Limited versus Halakha. If it may please this honorable court, the council would like to seek permission to collectively address the bench to the lordship. The lordship, if you are well versed with the facts of the case, shall the council move to the issues at hand, or would you like us shortly?
Whichever way you want.
It is up to your lordship, whatever you would like.
You are the counsel.
Actually, you want to allow the appeal.
I'm sorry.
You want to actually allow the appeal. If you want us to do whatever we want to allow the appeal.
Your lordship, I'll tell you the necessary facts that need to be known. Our client is looking for an apartment to buy in Bangalore. They came across a project called the Retreat in a newspaper ad which was being developed under a joint development agreement. And your lordships, according to the sale from agreement that was entered into, they would pay a sum of 35,95,000, in exchange of which within 36 months from when they get the commencement certificate, which is 4th of July 2012, they would get possession. And this person, our client, he got a bank loan. He repaid the bank loan within 5 years instead of the 20 to which he was given. However, the problem that occurred was after paying 90% of this amount, according to the payment schedule, the delivery of the possession was not given. And therefore, within a year of them giving them false promises, they sent them a legal notice asking them to deliver the possession, on the failure of which they invoked the arbitration clause. And even after invoking the arbitration clause from the other party, there was no arbitrator hired for the same, because of which a petition was filed under section 11 clause 6 of the Arbitration Act in order for the High Court to appoint a sole arbitrator. The arbitrator gave an award of about 56 lakh, which is what has been contested here under section 34. The council would like to move
This is 37.
34.
This appeal, which clause?
Under section 34, Your Lordship.
34 was before the civil court. Now there's a decision of the civil court or the commercial court. Commercial court has decided the section 34. What happened after that?
Yes, yes, Your Lordship.
Under which provision?
In this code, it's under section 37, Your Lordship. I was talking about the previous award. Would you like, would it be okay if I move to this? Your Lordship, firstly, it needs to be established. This will be dealt with in a threefold manner. Firstly, the existence of a breach of contract which gives entitlement to the award that has been given. Secondly, the legality of the award, Your Lordship, which has three major aspects. Firstly, the refund and the interest that is awarded on the refund. Secondly, the litigation charges pendente, right? And thirdly, the charge created on the property, Your Lordship. And lastly, it is essential to establish that the award does not go against public policy and is not patently illegal. Your Lordship, moving to the first issue that is at hand, which is the breach of contract itself. Your Lordship, there's a case known as Sapta Shukla versus Sankhet International, which talks about how the existence and the extent of the delay of possession itself is an admitted factual position. Your Lordship, once the developer causes a delay, it immediately invokes the liability that person has to pay compensation. And here, all the claimant here is doing is trying to get compensation out of such breach. Your Lordship, in the current scenario, the 36-month period was not abided by. And whatever reason the delay might have been does not fall under the just exceptions given in clause 6 of Exhibit P1, Your Lordship. Moving on, there was ignorance of every single legal notice that had been given, Exhibits P 9, 11 and 12, Your Lordships. Moreover, Your Lordships, what needs to be understood is that even the petitioner has not denied the delay. So there is a clear breach of contract which gives rise to awards that have to be given to the breached party. Moreover, Your Lordship, when it comes to the legality of the award itself, the first thing that needs to be taken into account here is that a full refund has been given.
of course, which has to be given because cases such as Anuj Biswas versus Capstone Construction and even the landmark case of Kaushal Rana versus DLF Commercial, they've said that if there's a breach of contract, you've not given possession, you have to fully
Why is
refund.
it a landmark? Who called it landmark?
Your Lordship, the DLF commercial case was very well known for the judgment that was given, and I'll tell you exactly why, Your Lordship. Not only was the refund given, but an interest of 18% per annum was given on that amount.
Was it an arbitration
Yes, Your Lordship.
from the DLF panel?
No, Your Lordship.
How did it apply to us?
Your Lordship, because the facts of the case were such that it was a similar situation where the builder, upon breach, because of delay of possession, was told to deposit the entire, return the entire deposited amount with an interest of 18% per annum. And Your Lordship, in this case, what was done was that the claimant was also given charges for the mental harassment and agony, which is something our client did not even receive, Your Lordship. Even though our client went through a great deal of mental agony on the failure of this possession. Your Lordship, in the same area, for an apartment of measuring the same square feet, they had to pay an additional 40 lakh.
You didn't file a petition. Why should we carry an on-road argument?
I'm sorry, Your Lordship.
You did not file you did not challenge the award. Did you challenge the
No, Your
award?
Lordship.
So why, how are all these issues relevant?
Your Lordship,
As
it's
to what mental hardship you suffered?
It's not relevant, Your Lordship, in this particular matter, but what is relevant is that the award that is given and the refund that is given is completely reasonable, Your Lordship. There is no case for this.
How do you get over the clause 13 which prescribes a particular amount of money to be paid for the deal?
Your Lordship, two things I need to bring to the table here. Firstly is again the Kaushal Rana case. Your Lordship, here the court had clearly said that in a case where this is a Supreme Court judgment, Your Lordship, this is complaint number 88 of 2012. The Supreme Court had clearly said that if there is a gross delay in turning over the property, then the jurisdiction of the court to give compensation is not constrained by the terms of a rate.
The court, not an arbitration.
Your Lordship, the Consumer Forum and the courts.
Arbitrator can't go beyond the terms of the contract.
Your Lordship, however, when it comes to the Indian Contract Act, it clearly states that when you're talking about giving interest on an award, the Indian Contract Act allows the arbitrator to do so unless it's specifically barred by the contract. I agree, Your Lordship, that the contract directly does not talk about an interest, but it does not specifically bar one either. And in compliance with substantive provisions of Indian law, it is clearly well within the powers of the arbitrator to do so, Your Lordship. And every other award that has been given is completely in compliance with the contract, Your Lordship. The refund has been given, the 18% interest per annum has been given, keeping in mind every fundamental policy of India, including the Indian Contract Act.
Is this the fundamental policy of Indian law?
Policy 18% is fundamental.
No, Your Lordship. What I'm trying to say is, Your Lordship, the Arbitration and Conciliation Act has a section 31 clause 7 clause B. Your Lordship, this clearly states that an arbitral award is to carry an interest of exactly 18% on the award.
If it is not specified, it will carry interest at 18%.
And Your Lordship,
But if it
is,
is specified, it is not.
however, Your Lordship, nothing is specified about an interest. There is a lack of any information with regard to the interest, which under the Indian Contract Act allows the arbitrator to give it on their discretion, Your Lordship, which is exactly the point I'm trying to make.
Is interest a measure of damages?
Your Lordship, the interest here is absolutely necessary, though.
It's a measure of damages.
Yes, Your Lordship.
Then if it's a measure of damages, then it's by section 74.
Your Lordship, even under 74, the Kaushal Rana case has clearly established that you do not have to stick to the terms that the builder has given. Moreover, Your Lordship, everything that has been given is within the terms of the contract. 1.5 lakh damages that have been given.
That's right.
Yes.
Only that is right.
Your Lordship, if the problem is the interest, it's the Indian Contract Act itself that allows it.
Will you give up interest?
Your Lordship,
That's not the award.
the court does not have the discretion of altering an arbitral award. It only has the power to either uphold it or set it aside, Your Lordship.
So if a portion of the award is wrong, can it set aside the entire award?
However, Your Lordship, it can set aside. Of course, Your
Suppose
Lordship.
I think it's 15%, there should be interest, can I set aside the entire award?
You can, Your Lordship, but the problem here is that 15% or 80% isn't an unreasonable amount.
It's not about reason. Why not 19%? Why not 16%?
Your Lordship, because the cases that we are referring to, every judicial precedent, even the Arbitration Act itself is talking about 18% specifically, which is why we're not asking for anything exorbitant. What would have stopped our client from asking for even 30%, but we are asking for 18% because that is what has been given in various judgments and that is what the law says, Your Lordship, very respectfully.
Where is the law say that?
Your Lordship, The Indian Contract Act allows
Says 18%.
It allows for, Your Lordship, the Arbitration Act allows for 18% explicitly in
How about-
subsection 7
How
clause
about
B.
the RERA Act? RERA Act prescribes a lower rate of interest. What do
Your
you
Lordship,
think?
the issue with that
And
is
that's
that,
a substantive law governing this subject matter.
however, Your Lordship, RERA was not brought when the matter came before the arbitrator. RERA wasn't even brought up as a defense, and in this stage, to bring up a provision that had never been previously used and reducing evidence that is case so consequential is generally not allowed by the court.
Bombay High Court has said that RERA is retroactive. So it's retroactive, then it applies to this arbitration.
However, Your Lordship, if you're talking about the RERA, we're talking about section 18 of the RERA. Your Lordship, under section 18 of the RERA, there is a case called Imperial Structures versus Anil Patni, where under section 18, even though it talks about the SBI's marginal lending rate plus 2% per se, Your Lordship, if the delay is so gross and it affects the rights of the person who has been breached, it is within the powers of the arbitrator to deal with the matter reasonably and give an award that is reasonable and just, Your Lordship. At the end of the day, we have to understand that every provision that is set out is there to protect the interests of those that are breached, Your Lordship.
What is the interest rate you pay to your bank?
10.8%.
That's the correct rate of interest you pay.
However, Your Lordship, what needs to be taken into consideration is again the fact that it's not just the interest rate we are stuck on. Your Lordship, I know this might not be relevant to this award, but Your Lordship, our client has been paying the rent for the 8 years of breach in which he should have gotten his apartment. He should have been living rent free in an apartment that he paid for. He paid 90% of the award, Your Lordship, he cleared his loan. It clearly shows that he had every intention to fulfill this payment. Your Lordship, he has been paying an extra rent for ages. Every rent receipt has been provided for. Moreover, he's paying an extra 40 lakh for a property in the same area with the same square footage, Your Lordship, and the mental agony people go through with regard to money, with regard to property. Everything, the facts of the case have to be taken into account, Your Lordship. That is the whole point here.
We feel we should enhance it to 24% now.
Your Lordship, we have asked for 18%, that is what we will be sticking to.
What do you say about 34 and scope of interference?
Your Lordship, 34 talks of, there are certain conditions that need to be fulfilled under 34, Your Lordship, and none of those conditions have been fulfilled by any of the circumstances, whether it be not being given proper notice of appointment of an arbitrator or not being given proper notice of the case, which is clearly countered by Exhibit P12, which are the legal notices yourself, Your Lordship. It also talks about something called patent illegality, Your Lordship. Now, which is a major ground against which most awards are set aside. Now, for patent illegality, Your Lordships, I'd like to bring your attention to the ONGC versus SAW case, which gave certain grounds for what would be patently illegal.
That was the old law. This was after 2015 amendment.
Yes, Your Lordship, I thought you were asking about section 34.
34 remains the same, but
Yes.
grounds have changed after 2015. Why you reckon ONGC was swap by 2012?
No, Your Lordship, all I'm trying to say is that something is considered patently illegal when it goes against substantive provisions of law or the Arbitration and Conciliation Act. I think, Your Lordship, every award that is given is within the ambit of every single one of these. Moreover, Your Lordship, when you were talking about Section 74, I think one thing that also needs to be understood is there's also Section 75 of the Indian Contract Act, which talks about when a party rightfully rescinds a contract, they are entitled to reasonable damages in accordance with the breach that has been done against them, Your Lordship. The applicability of every single one of these provisions needs to be
You're
taken.
saying 75 overrides 74.
No, it doesn't override 74, Your
74 is
Lordship.
the bar. You get only 2 rupees per square foot per month.
Yes, Your Lordship. And that is what has been
That is
given, Your
stipulated
Lordship.
in that.
Yes, Your Lordship, the only extra, yes, rupees 2 per month per square footage, which is what comes to 1.5 lakhs, Your Lordship. The only thing that was not provided for explicitly by the contract is the interest, Your Lordship. And because it wasn't provided for explicitly is why the arbitrator had the discretion to award it, Your Lordship. And that is all we're saying. Everything else, Your Lordship, even the litigation charges that have been given, there are multiple cases. If you would give me a second, like State of Orissa versus GC Roy, Raviji and Company versus Union of India, every single one of them says that giving litigation charges is well within the rights of the arbitrator. Again, unless it's explicitly barred by the contract. Your Lordship, if the contract itself had provisions that clearly stated that these will not be allowed, then that would be a completely different matter, but that is not the matter here, Your Lordships. And even the charge created on the property as security, Your Lordship, even if that is contested, you have section 17 clause 1 of the Arbitration Act, which is read with section 94 of the Civil Procedure Code, which actually allows a tribunal to attach a property for purposes of security, whether or not it is.
But that's only an interim measure of protection.
Yes, Your Lordship. I was talking
But
about.
yours is a final award on creating a charge. But
Yes,
and
sir.
that's a claim which you not made before the arbitrator as a main review. You did not ask for charge.
Exactly, Your Lordship. This claim was was awarded by the arbitrator himself, given the severity
Beyond the
of the
scope of
matter.
reference then. Under 34,
I was-
it's not the scope of reference.
Yes, sir.
So that goes in the award has to be.
Your Lordship, I think it is well within the discretion of the arbitrator to. Your Lordship, this is an interim measure. Like it was given
Not
a.
interim, it's fine.
Now it is, Your Lordship, but Your Lordship, it was given a security because it was only given that in case the property that he had paid for, the apartment and paid for, would be sold, only then would a charge be created on scheduled BNC property. It's a precautionary measure given the nature of the circumstances, Your Lordship.
So some incursion can be done in the award.
I'm sorry.
Some portion of the award will have to be set aside.
I very respectfully, Your Lordship, I don't think any part of the award can be set aside. It is not within the power of the court to do so. As far as I know, the McDermott International versus Burn Standard Company Limited said a court cannot
What
modify.
if they are unconnected to each other?
Your
What if there
Lordship,
are three parts of a claim which is awarded, each of which is unconnected to the other? So you set aside a portion of it and leave the rest as it is.
as far as my knowledge is, Your Lordship, you cannot. However, Your Lordship, every single claim and award here is very well connected and very well within the rights of the arbitrator to give, Your Lordship. If Your Lordship have no further questions, I would like to request to move to the prayer. Your Lordships, in light of the issues raised, arguments advanced and authority cited, it is humbly prayed before this honourable court to adjudge and declare that the petition under section 34 is dismissed and the award is not liable to be set aside under section 34 or pass any other order that this honourable court may
Still in
deem
34.
37.
So you want
I
37 to
apologize.
be allowed to dismiss.
I apologize. Or pass any other order that this honourable court may deem
Reducing the interest.
in light of justice, equity, and good conscience, Your Lordship. For this act of kindness, the counsel for respondent shall be bound forever. Thank you, Your Lordships.